what I'm arguing.
We actually have an opinion that says that it's unconstitutional to make homeless people not sleep, right?
Correct, Your Honor. And I think, I mean, I do know, and I think that's part of our point, though, is that we're not talking about the constitutional standard here, and we're not talking about what CBP has implemented more broadly as its own TEDS policy. We're talking about...
Are you arguing seriously that you do not read the agreement as requiring you to do something other than what I've just described? Cold all night long, lights on all night long, sleep on the concrete, and you get an aluminum foil blanket. Are you saying that that's okay?
And 2 credit to lie down, which they also said.
I find that inconceivable that the government would say that that is safe and sanitary.
I think what I'm arguing, Your Honor, is that I don't believe that the district court made the finding in the way that Your Honor just detailed it.
Everything I just said comes right out of the district court order.
I think our concern is that the district court really looked at a condition, looked at it, and again, as I said, I think sleep is clearly at the sort of one end of her findings. I think we also look at...
Which is your strongest argument then?
Well, I mean, I think what I would go to is when you start enumerating, for example, specific hygiene items, and the way that was done is that the court sort of enumerated these and say these fall under the rubric, these fall in the category of what could be required.
Again, it wasn't perfume soap, it was soap. It wasn't, high-class milled soap, it was soap. And that sounds, that's part of safe and sanitary. Are you disagreeing with that?
What I'm disagreeing with is that the court ultimately concluded these things would fall under here, and then simply by not providing them, you have violated that tenet of the agreement. And I also would note that in that particular...
What do you... Granted that the decree doesn't have a list of items that has to be supplied in order to be sanitary. What's a reasonable, in your eyes, what's a reasonable definition of sanitary that the court could enforce?
Well, I think what I would ask is, what I would say is I would ask that the court find that the conditions were not safe and sanitary. What the court found is these things fall within that category, and by not providing them, that's an automatic breach of the agreement.
Well, I don't know if it's automatic, but to me it's more like, as Judge Fletcher says, it's within everybody's common understanding that, if you don't have a toothbrush, if you don't have soap, if you don't have a blanket, it's not safe and sanitary. Well, wouldn't everybody agree to that? Do you agree to that?
Well, I think it's...
Let your yay be yay. Let your nay be nay.
Reason to find that those things may be part of safe and sanitary.
Or
This fucking bitch.
what do you say maybe?
Why you say maybe? Because she's the devil.
A person doesn't need to have a toothbrush, toothpaste, and soap for days.
Well, I think in CBP custody, it's frequently intended to be much shorter term. So it may be that for a shorter term stay in CBP custody, that some of those things may not be required.
Yeah, but I don't think that was the situation that the court was confronting. I mean, it wasn't as though those people were there for 12 hours and then moved on to the Hilton Hotel. No, they were there for a fairly sustained period, and at least according to the evidence that the judge believed, they weren't getting these things for a fairly sustained period.
Well, I do want to clarify that the judge did find that in Ursula, in one of the CBP facilities, that many of those things were present,
right.
And that the evidence did show that that minors spent a much shorter period of time. That there was only a small percentage of minors who weren't moved to Ursula very quickly.
So just to clarify, at some point in your brief, you appear to be saying that safe and sanitary has no independent meaning, and that the following, there's another sentence that follows it that has some details, and that's the only thing you're required to do. I don't understand you to be arguing that now. Is that correct? That's what your brief said. Right? Your brief seemed to say that safe and sanitary had no independent meaning.
I don't think it has no independent meaning, and if that's the impression our argument gave, I apologize. I think that the position is more generally that to impose specific specific enumerated meanings that are not contained
Ninth
in the
Circuit.
agreement, without, in fact, reaching the ultimate question of were the conditions overall, in general, as a general matter, safe and sanitary, is not a correct finding of breach.
No, but you see, under that approach, if the district court were to conclude, no, they were not sanitary, and all it could do is say, fix it, they couldn't tell you what to do, right? They couldn't say, you have to provide it, so all they can do is issue an order saying, make it sanitary, right? I mean, that's what these details are there for. Isn't that the purpose, to give a concrete meaning to the term?
I think.
I mean, if CPB got an order saying, we want your facilities to be sanitary, they say, fine, we'll make them sanitary. But who knows what sanitary is?
And I think that
Bring
then
it out.
goes to whether to what level the agreement could be enforceable. That's
by the way I'm getting. So you're saying maybe the agreement is so vague that it's unenforceable. That's almost your argument, isn't it?
To some extent, yes, Your Honor.
Burn.
I think that if the term in the agreement requires an after agreement interpretation by the district court, then yes, that does constitute a vague term that the parties didn't sufficiently clarify in reaching agreement.
Wow.
Well, let's hear from the other side, and we've taken you 18 minutes and 52 seconds over time, but we will give you a chance to respond.
Thank you, Your Honor.
Fucking
You've lost a piece of
bullshit.
paper. There's a piece of paper that I don't know what it is that fell down.
All right, let's hear the other side.
Thank you.
May it please the court, Peter Shea for the plaintiffs.
These are the
Yes, I'd
lawyers for the children.
maybe like to start with this issue you were grappling with about
I'm sorry?
ICE releasing children to non-parents, and the argument in the appellate brief by the government that somehow if it was going to release to a non-parent, that would convert that child to an unaccompanied minor, and therefore only under the TVPRA of 2008.
Well, even if it did, I mean, it seems to me there may be something in that, i.e., if they're not going to be able to be taken care of by their parents because their parent is in detention, and after the last iteration of this case, you're not going to get that parent freed because of this agreement. But still, I don't. Maybe I'm missing the stakes here. But whether it's whoever it is, whether it's ICE or ORR, if they're still bound by the agreement, what difference does it make?
Well, I guess the first point I would make is that that's an argument they never made to the district court.
Well, that may be true.
And if you look at record of excerpts, page 26 and 27, Judge G deals with their argument about why ICE will not, even though the settlement says that from the time of apprehension, the defendants will make and record prompt and continuous efforts aimed at the release of children under paragraph 14. And the settlement doesn't say, oh, if the child is with a parent locked up by ICE, somebody else has to make that evaluation.
It would help me to know why you care. If the agreement is still binding on ORR, then why do you care?
Well, it is binding on
Right,
ORR.
okay,
There's no
so
question
therefore,
about that.
why do you care?
But as a practical matter, if a child is in ICE custody, then under the terms of the agreement, it is ICE that has that kid in its physical
Okay,
custody.
but their position is, well, ICE has to hand it
Let
over
him
to
talk,
ORR.
bitch.
Well, if they don't hand it over to
Stop
ORR,
interrupting
then they
him.
have a problem under TIFRA, and if they do, then ORR
Telling
is
you,
still bound by the agreement.
these
So
two
what's your
motherfuckers are in
problem?
cahoots with that other
Tens
bitch.
of thousands of children who've been detained by ICE. The government cannot point to a single case, and we're monitoring this all the time. We're not aware of a single case in which a child has been transferred from ICE to ORR.
Then they've
just
got
so
a
that
major, so then if they're coming here and telling us that that's what they're supposed to be doing, then they've got a major problem. That's what
Well-
they're telling us. They're telling us that they're supposed to be handing them over to ORR, and now you're telling me they never do. Well, that's a big problem.
they never
It may not be
do.
this problem, but it's a big problem.
And right today, we have a situation where once a month a kid is dying in CBP custody.
Well, maybe you're much better
because-
off with an order than that says
Notice
that they
she
have
keeps
to hand them over to
interrupting him.
ORR right away, because that's what they're saying.
They're not turning them over because ORR has no bed space.
Well, you know, it sounds to me as though this is something that's better addressed by the district court in the first instance. It doesn't sound as though the district court was even made aware of this issue.
It wasn't, and if you look at the argument they made in the district court, which the court addresses in some detail at page 26 and 27, they don't argue anything close to the notion that these kids are unaccompanied, because they're not. I mean, the statute, you cannot just take any child and transfer that child to ORR. Under the terms of the settlement, paragraph 14, 18, and 19, whoever has custody of that kid, Border Patrol, ORR, or ICE, is supposed to make and record continuous efforts aimed at the release of that child to a list of relatives listed in paragraph 14. And the only thing that ICE argued in the district court, and the court discusses this in detail at pages 26 and 27, is they just said, they didn't say anything about the TVPRA. They just said, oh, ICE doesn't have the capacity or the expertise to do this. You cannot take, under the federal statute, and they never have taken a child who is detained with a parent and suddenly define that child as an unaccompanied minor simply because the mother says, I would like my child released to my mother, the child's grandmother in San Francisco. That is supposed to trigger, and historically has triggered, a brief investigation. Certainly they can assess the household, and they should assess the household. But that triggers a brief investigation into is the grandmother willing, capable, and able to take care of that child? That's taking place while the child is with the mother in a family detention center. Under federal law, you cannot suddenly define that child as an unaccompanied minor just because the mother said, I would like the child released to my sister. Now, if the ICE determines, as it historically has for 33 years, that the grandmother is a good placement, and they place that child with that
I'm ending this.
Even then,
Y'all gonna pay for this shit.
Define that child as
Y'all, you fucking devils, y'all gonna pay. All I gotta say. Howard Shine is watching you motherfuckers. Shalom.